welcome everybody to the AMI Mining Coffee Chat. My name is Andreas Farge. I'm a senior analyst at AMI, and I'm going to be filling in for John at the beginning of this call. I am happy to introduce this great panel of speakers. We'll be diving into glacier law in Chile. Please do remember that this call will be recorded, so to please mute your microphones if you're not actively speaking. Let's take a moment to read our legal, or to look at our legal notice. You could refer, this is just stating that AMI has verified the accuracy of the information provided, but does not assume responsibility for any action taken on this information. Before we head into the introduction to the panel, a little bit about AMI. AMI is a risk consulting firm. We typically help mining companies at two stages. The first is the pre-investment stage, in which AMI handles due diligence prior to investment, and AMI also supports in the operational phase for continued risk monitoring. In recent years, particularly above the ground and local community risks have gained importance, and AMI has a local network to continuously provide this eye on the ground. Going into our panel, we have Sergio and Sebastián from Brochue, who have been working for the past 20 years in Argentina and Chile, supporting large-scale mining projects, and have continued to develop these projects. Dr. Pablo Wainstein is a senior civil hydraulic engineer who's based in Calgary, and Patricio Leyton heads the mining and energy practice at FerradaNehme, based in Santiago. The panel will be moderated by John Price, the managing director of AMI, who joined our call.
Thank you, Andres, and apologies to everyone. I had a call that unfortunately went way over time. Great to be here. Thank you again to Sergio, Sebastián, Pablo, Patricio. Really appreciate your support and what should be a very interesting discussion. As a reminder to everyone, please put in the chat mode any questions that you may have, and we'll certainly do our best to address those. And as a reminder to us all, if the panelists agree to have this recording circulated, then we will do so. Otherwise, we'd appreciate it that this remains a private call in the meantime. If I could begin, please, with Sergio and Sebastián. The current Peronist administration has publicly expressed its support for mining and has even made some gestures, I think, in support of that, although certainly some people in the cabinet have proven to be anti-mining. But generally, one could say that the economic necessity of gaining foreign currency in Argentina, having sat and witnessed the success of Chile and Peru for so long in terms of mining, bringing FX security to those countries. But one of the great obstacles and great source of investor concern is the National Glacier Law. Can you provide our audience with an overview of that law and the accompanying glacier investor inventory that was established by the law? And what are some of the risks to mining investment, particularly in those provinces, where glaciers are found? And there's a very interesting but controversial case we understand underway, where the scientist who was hired to develop the inventory of glaciers, Dr. Ricardo Villaba, right now is under investigation or maybe even indictment. And maybe you could shed some light on that case and why that case is important to understand the greater context of the glacier law and the application of that law to mining projects.
Sure. Hi, everyone. Thanks for the invitation. Thanks to my co-panelists here, a lot of familiar faces. So it's quite a broad question, and we're given 5 to 7 minutes, so I'm trying to keep it brief. There's a lot to talk about this, of course, but I'm going to try to provide a general overview and, of course, open to further questions as they come along. Just to give you first an idea, Argentina is a federal country, so the federal government has all the powers that were delegated by the different provinces through the national constitution, and the different provinces retain all those powers that were not delegated expressly to the federal power. This means that also each of the provinces are the owners of the natural resources existing within their own territories. This covers, of course, not only mining and oil and gas resources, but water resources and also glaciers existing within the territory of a province. Also, based on our national constitution, the Federal Congress is enabled to issue what it's called minimum environmental protection standard legislation. And based on such power, it has issued this National Glacier Law, which is intended to set up certain basic minimum standards that all of the provinces should follow, both when applying law and also when issuing their own provincial environmental protection legislation. So in addition to that, provinces are the ones in charge of applying all of the mining and environmental legislation within their territories. This means that they are in charge of applying also the glacier law and their own provincial legislation. So when it comes to a mining project that wants to conduct any sort of mining activity, the authority in charge of approving that environmental impact report is the provincial authority, which has to respect the minimum standards established by National Glacier Law. With that basic overview of our congressional federal system, which is necessary to understand, the evolution that this law had, I'm going to proceed to describe basically the structure of this minimum environmental protection standard law called the Glacier Protection Law. One last important thing to mention is that based on our constitution, Congress by no means is allowed when issuing this sort of legislation to invade or affect the provincial jurisdictions or powers not delegated by the province to the federal government. So that's an important limitation established under our constitution. Basically, the National Glacier Law has a structure such that the first thing to say is that it has a very unprecise language in terms of what's protected under such law. And it has some sort of a vagueness where there is not a lot of uniformity among the different articles, and there could be some space for contradiction, and this of course provides a lot of uncertainty, and this was the case when it first came out, right? When you have that situation when there is vagueness and uncertainty, of course you have different sides in trying to interpret in the way that they consider should be interpreted, and you have pro-mining interpretation and anti-mining interpretation, and that generates uncertainty, right? So the structure that it has is that it protects glaciers, but also, and this is the thing that generated most of the problems, the periglacier environment and their functions. So there, at first, it also mandates for the creation of a glacier inventory where all the geoforms should be included. All the geoforms that are protected under law should be included, both existing in the glacier and periglacier environment. It also establishes that the activities already in place at the time of the issuance of this law should be subject to reevaluation, and the new activities should be forbidden if they could affect the protected geoforms or the periglacier environment. So an important thing to say is that this law had a previous bill very similar to it, that it was vetoed by the executive power based on considering that it was unconstitutional for affecting different non-delegated powers by the province, such as the power to conduct environmental evaluation within the provincial territory. So at first, as I was saying, this generated a lot of uncertainties in terms of what was the subject of protection by the law. Was it the glaciers by itself? Was there a protection for the glacier functions in terms of water providers or water reserves? Or was it the whole periglacier environment that contains all these geoforms? And this vagueness of the law didn't help with finding clarity on what was subject to protection. And it was very important to determine what was subject to protection because of the important restrictions that this law has, right? In terms of reevaluation of existing projects and prohibition for new projects that could affect that it's subject to protection. As years went by, many of these uncertainties have been clarified. And basically, those clarifications came through, first of all, this precedent where the decree vetoed certain parts of the previous bill, stating that it was unconstitutional. It gives way to the sort of interpretation that would be reasonable and constitutional with respect to this new law. Also, the Federal Environmental Authority at the federal level has established the criteria for the creation of the inventory and what sort of geoforms should be included in that national inventory. And it established criteria such as that all geoforms should be included in the inventory provided they have an existence of at least 2 years and they have a surface of at least 1 hectare. These two features are very important, and those geoforms have been included based on the precautionary principle, where you include all geoforms that may have a chance to have a relevant water function. If you go to the congressional discussions in terms of this law, it's very clear that what it's subject to protection are the main water functions that these protected geoforms may have. Not the whole periglacier environment, because by itself, the periglacier environment does not have a water function. What it does have a water functions are the geoforms that are included in glacier or periglacier environment. So once the inventory was ready, and it took about 6 to 8 years, there was a lot of uncertainty of what was the scope of protection of this law. Having the inventory helped, the inventory completed, and also, there was a ruling by the Supreme Court where a mining company and also a province filed a constitutional claim stating that the law was unconstitutional. I think some of the panelists are going to refer to that case, but just to say, in terms of helping with certainty, that ruling by the Supreme Court helped providing certain guidelines that help the reasonable interpretation of the law as well. So what are the main remaining problems? The main remaining problems are still, anti-mining groups that try to force an unreasonable interpretation of what's protected under the law. And this has to do, like the case you mentioned in your question, where the president of Yanigla, which is the institute in charge of creating the inventory, has been accused of not fulfilling his duties as a public servant, and accused of, when completing the inventory, basically narrowing the scope of protection that the law intended to have, and anti-mining and groups sustain that the law intended to protect not just the geoforms with relevant water functions, but all of the periglacial environment, trying to extend the scope of protection and restrictions and prohibitions. The thing is that even if at the end of the day, in this case, Mr. Villalba is found guilty, that would have no direct legal effect on the validity of the inventory, which has not been challenged so far. And it's not just the inventory with the geoforms, but it would need a successful claim, not just against the inventory, but against the criteria that were designed in order to determine what geoforms should be included. And those criteria have been issued by the Federal Environmental Authority in Argentina. So at first there was great uncertainty, and as things took place, like the regulatory framework, the inventory, the ruling by the court, and there was more and more certainty in terms of the limitations on the scope of this law. But of course, you still have anti-mining groups that try to force the content of the law to try to have mining not happening. And as a practical matter, and this is the last part of my answer, what you can find are different provinces, pro-mining and not so pro-mining, that have different approach when building up and having a bulletproof permit in terms of glacier evaluation. Of course, this is a challenge. Of course, things have to be well prepared in order to have a solid permit, but it's not impossible, and it's quite a safe ground in those provinces that are pro-mining, that tend to interpret the law in a reasonable manner, following the guidelines of the Supreme Court. But still, you have to be careful and prepare all the submissions in such a way that help the reasonable interpretation of this law, which doesn't have a proper technique and has a lot of vagueness, that has been solved through other aspects, as I was mentioning, but that still has some level of risk if you don't take the proper measures when dealing with it.
Right. Thank you, Sergio. A quick follow-up. The mapping of the inventory, is this public knowledge? If I'm a mining company and I want to understand if my concession is going to touch that or not,
yes.
Where do I go for that?
It's in a web page, and it's published, and you can immediately access for each hydrological basin.
glaciaresargentinos.gov.ar.
We can provide that.
Yeah, maybe if you could just punch that into the chat, that'd be great.
Yeah.
I think you addressed.
But important to say that map, it's not only useful in order to determine whether there is overlap between the mining activities and the glaciers, which would be a direct impact, but it's also worth taking into consideration to analyze indirect impact over uncovered glaciers, like dust dissemination or anything like that. So it's quite useful to do an overlap between that map and the activities to be performed.
Right.
And of course, another study that authorities don't have that advanced yet, and sometimes the companies need to do it, is to, even if the geoform is included in the inventory, it's worth analyzing whether it has or not an effective or relevant water function. Because at the end of the day, if the law is well interpreted and the water function is protected, the fact that it's in the inventory doesn't mean by itself that affecting that geoform would be affecting what the law tends to protect. But that you have to prove in your evaluation, right?
Yeah, got it. Okay. Thank you so much. That was very exhaustive and complete. Appreciate that. I want to remind everyone that we are in speaker mode, which means that if any sound emits from your microphone, the camera switches to you. So I believe, Oksana, you had your microphone on. So if you're not speaking, please keep your microphone off. Sebastián, Sergio certainly addressed a lot of the concerns that we had around the glacial law, but there was, and I think Sergio made light of it, but there was a Supreme Court decision rejecting the Barrick Gold and San Juan province's challenge to the constitutionality of the law. And this was, celebrated by the anti-mining community as a victory. Can you help us clarify a little bit what that decision actually helped establish?
Yeah, sure, Sean. Well, the first thing to say about that ruling is that it was not a victory against big mining, but to the contrary, I would say that the case and the ruling were a victory for the plaintiffs. Why? Why is that? Because the main let's put us on 2010 with this law, with this vague and uncertain law in terms of what was the purpose and the meaning and the scope. The main purpose of filing these cases was to prevent environmental NGOs legal action against the continuity of the operation of the projects. There was a real danger there, leveraged by the fact that by alleging the existence of this precautionary principle and the lack of certainty about what was protected, which kind of geoforms were located in the vicinity or in the area of the projects, was sufficient argument to stop the projects or the mines until further information was obtained. At that point in time, there was no inventory, and there was no deep knowledge about existence of geoforms or protected geoforms in the area of the projects, aside of whatever information was included in the environmental impact reports submitted by the companies to the provincial environmental authorities, the competent environmental authorities in the provinces, which was also not known by the public or by the NGO. So in that scenario, I would say there was enough danger to justify the mining companies with existing projects, either running, operating, or building, or moving forward with exploration, to go to the courts and seek protection, mainly to block, as I said, NGOs' legal action, stopping the projects. At that point in time, gaining time was important to let the new glacier regulation evolve towards a better definition and understanding of what's going to be protected under the new law, right? So in that context, some mining companies filed a legal action with the local courts, challenging the constitutionality of the glacier law and asking for a precautionary measure, blocking the application of the glacier law in their projects until further certainty is obtained. That had the effect, the practical effect of blocking NGOs, and with the Monday newspaper. That was a good move because the projects continued to operate and to run without impediments coming from this law. So from that perspective, the goal that was with these legal actions was achieved, and the precautionary measure was obtained. Then the projects were protected. Then, when the province joined the case, due to procedural rules, the case was sent to be heard by the National Supreme Court. The National Supreme Court, this is one of the cases where bad news are good news, right? Because one of the things that happened there at the National Supreme Court was the court decided to revoke the precautionary measures based on the argument that the glacier law was not jeopardizing the projects. There was no evidence of danger in the national glacier law preventing the projects from continue operating. So since there was no danger, there was no reason for a precautionary measure to exist, which was a good news for the projects, right? Because there wasn't no danger of being stopped.
Let me hold you there, because I appreciate the clarification, and I think that that really is helpful, because certainly people who read the media might not have arrived at that conclusion. But I want to bring in Pablo Wainstein, who's based in Calgary, but has done a lot of work in the glacier areas of both Argentina and Chile as a hydraulic engineer, and has advised companies on, you know, what they need to do. Pablo, welcome. And can you please help us understand what companies are doing to address the provisions of the National Glacier Law in preparation of their environmental social impact assessments, which at the end of the day is the process that, where if approved, they can move forward, but is where the uncertainty lies for some of them?
Thank you very much, John. Yeah, I've been advising mining companies on the cryosphere and hydrology of mountain areas for now 20 years. So I think that the current law in Argentina and the proposed protection law in Chile have been pushing a paradigm shift, as I would like to call, in the understanding that actually before, usually projects have a design, and then the environmental impact assessment assesses the impacts or the potential impacts, and then mitigation measures were set in order to cope with those possible impacts. There is a paradigm shift here that I've seen that fortunately companies are being very proactive to increase the knowledge that they have in the cryosphere, glaciers, permafrost, periglacial environment, and incorporate that knowledge derived from highly robust, internationally accepted studies onto the design itself. So it's a bit of an upside down approach in that sense, which is fortunate and which has helped quite a lot in the approval of permitting and the acquiring of social licenses, which is two different things in that sense. Now, something else that has happened very nicely is what I called listen, and when you thought that actually you were done understanding and listening, listen a bit more. So mining companies have opened to this new challenge and opportunities to understand this environment, which is highly dynamic, by listening, which is key. So listening is key for all the stakeholders, the communities, the regulators, authorities, the society in general, and the investors. If we don't have that good communication and the project does not listen to the needs of all these stakeholders as in a holistic way, then the project will not have as good as an outcome. Now, it's key that companies have been having a comprehensive approach in between the corporate side of things, the legal teams and the technical teams are joined together, and they work very tightly together, because it can't be the fact that corporate decisions do not take into account these technical decisions. So this is, in that sense, a highly crucial aspect that has to be taken care of. We need to be very innovative in all the technical aspects, in the cryological, the hydrological or mountain hydrology aspects, water management, which in essence is the key in my understanding of the glacier protections law. So the center in essence is water. How much water, if these are strategic reserves of water or not, and how they could potentially be affected, and the understanding of that. So I would say, to wrap up my answer in that sense, and to summarize, I've seen that mining companies have very nicely adapted to the challenges and to the opportunities to understand the cryosphere by this paradigm shift in essence, incorporating this knowledge into the design process from very, very early on, and listen to all the stakeholders and apply very innovative and robust studies and methodologies that must be accepted internationally in order to decrease the incongruencies in between the stakeholders that in essence are international: investors, the mining company itself, experts, and then locally authorities, communities, NGOs, etc.
Thank you, Pablo. I mean, I think it's really, you've helped remind us that there are two different paths here. One is the legal path and protecting yourself and being compliant with the law and making sure that you can defend yourself through the courts. And the other is, of course, the ability to sell the project, not just as a compliant project, but as a project that should not concern communities. Sebastián, I know you wanted to add a little bit more around this particular issue, so please take a couple minutes to clarify some more.
Thanks, John. Yeah, just a brief, just to say that in this particular cases, the Supreme Court did not confirm that the Glacier Law is constitutional. Just to say that there was a situation of lack of case because of the inexistence of dangers to the specific projects that were part of those cases. But the door remains open to challenge the constitutionality of the Glacier Law in any other specific situation where there is a real affection of danger to a project. Also, the Supreme Court kind of complained because it says that these kind of issues need the federal government and the provincial governments working together to see and work on how this should work, balancing all the rights and interests at stake, and focusing on sustainable development, right? Also, this ruling kind of clarified that the criteria to be considered is that the protected geoforms are those included in inventory, and as Sergio was saying, and they are relevant or protected to the extent they have a relevant water function. So this is not imposing, this glacier law is not imposing an absolute prohibition to conduct mining activity or for the provinces to analyze whether a specific project can be analyzed from the environmental perspective. Of course, if during this environmental review it happens that there is a prohibited activity, then it should not be approved. But this law is not blocking, again, absolutely blocking the possibility of reviewing any kind of project from the environmental standpoint or from the glacier law standpoint. Thank you.
Thank you. I want to shift gears a little bit now and bring in Patricio Leyton, who's based in Santiago. Patricio, a prolonged drought and water scarcity in Chile, particularly in the north, has heightened public awareness of the threat of global climate change. You have direct experience as the leading lawyer in several mining cases. Can you speak to us about these cases and how they've impacted the drive for glacial protection legislation in Chile, and provide a background of the glacier legislation currently advancing through Congress? And could you also provide your opinion regarding the probability that this legislation passing and the potential risk it poses to mining investment in Chile?
Thank you, John. Good morning to everyone. That's like 4 questions in one. I'll try to be brief because I want to keep it general. I want to keep it simple. I want to keep it in the concepts. And then if we get further questions like the one we're getting now, I'm certainly more than willing and able to go in detail there. But let's start from just 1 minute about myself. And this is relevant for the responses that I'm providing. I'm an optimist, and I am. I've been doing permitting and mining permitting for the past 25 years. And Chile today is going through a very relevant discussion among constitutional laws and certainly glacier laws. But we're discussing a lot of things. Currently today, we're discussing a general tax reform in order to provide a solution to the COVID situation. And that's relevant. It's relevant for the context, how do we look forward to Chile? And again, I think I'm an optimist, and I'm certain that we'll be able to come forward to the solutions that we have, to the issues that we have today, and the issues that we will have in the future. Two mining projects in the past were the ones that draw the attention of the people to the environment, and in general, the citizens, on the glaciers. Permitting in the 90s started formally in 94. And one of the few projects, or one of the main projects, actually the four of us were involved, was relevant on driving and bringing the attention of people on these issues. Now, as you well said, that's how things started. And the first draft bill started in 2005. But currently today, the concern of the people is not really on mining and glaciers. Yes, true, is what we see most. But today we have climate change. That's a matter of fact. That's an issue. We see it happening today. Today, glaciers are under risk of disappearing, not because of mining. They are under risk of disappearing because of climate change. And that's what's bringing people together in order to try to regulate this issue. Is it really necessary to have a bill on glaciers? Most probably no. Glaciers, and particularly thinking about mining. Mining already is being regulated, severely regulated, highly regulated, in the relationship with glaciers. Glaciers are protected under environmental legislation. We don't have a specific bill. And that's what's being discussed today. So what's being discussed today in Congress? In simple terms, and again, to keep it broad, I like to put it that we have two positions. And today, the one that is being approved is, in simple terms, the one provided by Sergio as to the Argentinian legislation, which I would consider a very conservative legislation, a very pro-glacier protection. Now, we are a mining country. We need to develop sustainably. We don't have to choose between mining development and glacier protection. I think that's where the challenge is. And I think that today, the bill that we have in Congress, at least the position that is advancing more forward, it's on the more conservative side. I'm sure that we will have to move to the center. The mining industry has proven to Chile that it's a key pillar to the development. Today, during the pandemic crisis, was one of the few activities that was able to carry forward and to carry out very well. Safety measures of development, they actually work fairly well. And maybe the price of the success is the fact that actually in Congress is one of the bills that is moving very forward very quickly is actually a royalty mining. But again, it's another discussion. Let's keep it aside. But the point that I want to make is that I don't think we Chileans see mining or the glacier protection as a restriction to mining. I think today the bill that we have in Congress, at least the way that it's moving forward, yeah, sure, is restricting too much. But I'm certain, and again, as an optimist, I think we're going to move to the center, considering the importance of mining, and most probably looking for a regulation that will have to balance, on the one hand, development, on the other hand, protection. And we'll probably have to move into the details. There's no discussions that glaciers, rock or white, will have to be protected. But how do we regulate the surroundings, the glacial environment around this issue, independently from the definitions of a periglacier or permafrost areas that are currently being regulated, but extremely protected? Most probably keeping the focus on the glaciers themselves, and the regulation surrounding them is probably the way that we're going to move forward. Now, how I think, in a brief minute, that this will limit mining, or what's the risk for mining activities? Again, considering that I think we have to move to the center, to this balance, I think that it will not be a risk. It will be a challenge, but a challenge that will be manageable. I think we have the techniques and the knowledge in order to understand the developments of glaciers. And I guess the key focus will be how mining activity actually develops without impacting or without imposing a risk to them. Now, finally, and this is in 10 seconds, if this bill going to pass, and that's probably the key questions, it depends really. If you would ask me a month ago, I would have told you yes, and because a lot of things were happening, I would say yes, because the bill was moving very fast. Now, a week ago, I would have told you no. No, why not? Because we have huge challenges to be addressed, and the positions between the developers and the conservatives were really far apart. But today, I think we have a really important opportunity to reach that agreement. And why? Because one of the key promoters of this glacier protection legislation is the president of the Senate, and today she's driving the negotiations with the government. And most probably she'll be able to succeed. The government understands that they have to reach an agreement, and if they reach an agreement, that's probably going to pave the road for the other agreements. And I think it's going to be a neat opportunity, a great opportunity to reach a reasonable agreement on glacier legislation and the protection of both the activity and the glaciers themselves.
Excellent. Thank you, Patricio. I mean, I think you've pointed out a couple of really key features. One is there's enough economic pressure to bring together these divergent political views to find a solution so that glacial protection and healthy mining industry can coexist. And the other is that though obviously a particular project in a particular place can have a short-term and immediate threat to a glacier, the far greater threat to glaciers as a whole is global warming. And as somebody who's considers himself a mountaineer and has climbed mountains in the Andes and probably in 4 different continents, I've seen it. I mean, I see it every year when I return to Europe. The glaciers are shrinking and shrinking and shrinking, and that in spite of having amazing laws to help protect them. Pablo, you've walked probably on more glaciers than anybody in this call, and you know, you've studied both the Argentine law. I'm sure you're well aware of the Chilean legislation and the language around it. Do these legislations, will they actually protect glaciers? And will they protect them enough that mining practices will change in such a way that 50 years from now, these two, the industry and glaciers, can still coexist? What is your sort of future outlook as to these laws and the future prospects for glaciers in this part of the world?
So thanks, John. I think we have to go back to the genesis of the laws of the two countries. And yes, I've been advising and working on Argentina and Chile for 20 years on these matters, but we have to remember that in Chile, there is the decree called Decreto 40, or Decree number 40, that actually obliges you to go into the environmental impact assessment system if your project is located nearby a glacier. This is quite different from Argentina in a sense, where the society felt a bit that glaciers were more unprotected. And then the genesis of the Argentinian law started. Now in Chile, that is not the case. Glaciers are not entirely unprotected. You have to conduct a thorough environmental impact assessment if you're close to a glacier. So in that sense, does a bill on top of that protect it, or it comes more as adding incongruencies? Well, the common denominator of all this, I think, is climate change, as Patricio pointed out. And the challenge is to discriminate what climate change is doing from what mining activity may be doing. That is, in essence, the core of the challenge here. Why do I emphasize this? Is because by passing bills as they are structured now, we've got several points that I think that they need to be solved in order to really protect more. First of all, don't confuse protection with preservation. You cannot preserve a glacier. It's not a painting that you put in a museum with a controlled environment in order to preserve it for next generations. Climate change is doing its matters, unfortunately, so you can't preserve them. You could protect them from direct or indirect impacts from different activities, yes. However, those need to be thoroughly understood. When you put a bill together that has fixed values of aspects, fixed buffer distance, or even uses terminology and concepts that are not internationally well accepted and locally highly modified, in my view, actually, you go into more incongruencies than helping not. However, I do agree with Patricio that we've worked together for many, many years, that there's a tendency now to reaccept the fact that concepts have to be internationally accepted, that sometimes fixed distances or concepts do not represent the dynamic nature of the glacial and periglacial environment. In essence, the glacier protection law proposal in Chile has the nice opportunity to become, in that sense, a bill that enhances the need of understanding the cryosphere, not just putting together fixed limits, which are never good in a sense, because they don't understand the dynamic inherent to the environment. So it has that nice opportunity to enhance the understanding, or the need, or push more the understanding of these complex systems, and use internationally accepted terminology and so. So in a way, just to wrap this up, climate change is the common denominator here that we need to distinguish potential impacts from climate change and mining companies. And let's not confuse preservation with protection. And in essence, we need to educate the public, because all these laws come from what it joins us as human beings, which is fear. So we are fearful of something, so then we want protection. Now, if we are educated about those fears and those myths are debunked, then we feel less fearful. And then the protection can be more understanding, flexible, and comprehensive.
Great, thank you. We have a couple of questions and a comment from the audience, and one deals with Chile and the dynamic there. Another takes us back to Argentina. I want to touch the one in Chile first, and Patricio, I want to sort of plant a scenario for you, because I think what you just talked about how, you know, a month ago things looked one way, a week ago they looked very different. That speaks to the flux of political dynamic in Chile this year, this being the most important political year that in my living memory of Chile, certainly going back to the dictatorship. Let's assume that the Constitutional Assembly elections put together a body of people in charge of building the next constitution that includes enough of a right or center leaning that the new constitution itself will not be a vehicle of great change in Chile because of the high hurdle it takes to actually change the constitution. If that is the case, and certainly a lot of people have told me that that is probably going to be the case, then those who are frustrated on the left, when it becomes clear to them that the Constitution is not going to change that much and is not going to provide the kind of legislative changes or legal changes around environmental issues that they were hoping for, that they're going to then pivot to a more radical posture in the congressional elections towards the end of the year to help as the sort of last hope to deliver something more meaningful change to provide environmental protections in Chile. Is that a reasonable scenario, and how might that change, you know, at how you're reading things right now based upon what you saw a week ago?
You're right, John. Now, first of all, if I would have a crystal ball, and I'm not making an irony of the question, I'm just making it general, I wouldn't be a lawyer and I wouldn't be here. But we have to work with what we have, and one way or another, and that's the tough part of our job as lawyers, to provide certainty to projects or to an activity it's by definition uncertain. Now, I take the same position that you are feeling that are you getting from the people that you talked in Chile to. It seems too that we'll get sufficient middle base left, right, moderate left, moderate rights that will provide the driving force. I don't think no one is going to get 2/3 of the left, not 2/3 of the right, hopefully 2/3 in the middle. That's the path that we should forward. And I think that's the environment that I feel. Again, as I said, I'm an environmentalist, optimist. Juan, I know he's challenging me, but I know he's suffering much more closer than I am, the glacier issue, at least today. I think, though, that it's true. You might not be able to, or you might not drive the process to extremes, but there will be space for all positions in the constitutional discussion. So I think, hopefully, and this is important, hopefully, all voices will be triggered to that, and I think attention will drive there, or even from extremes. They might not obtain something, but that's where you're going to have the bouncing board to discussions. Now, how will that impact a glacier bill? I don't think that's going to be the driving force. If you ask me where positions will go, it's a water law, the water code. I mean, water code still needs to be discussed. There's been very interesting to Supreme Court decisions that granted the human right to water, and that makes sense, although that will be certainly included in Constitution, but we haven't been able to modify the water code yet. If you ask me where the extremes might go, it's probably there. And why not? And again, this is an opinion and certainly very discussable. Why not the glacier discussion? Because I'm putting I'm betting a lot on the moderate left. I think that up to now, the moderate left has extremed their position in order to challenge the government's position. The government's position today is very weak. I don't think they need to challenge them anymore. And I think what they are doing now is trying to agree with the government in order to be the solution forward. That makes sense for the Constitution, that makes sense for the COVID crisis, and that makes sense for the glacier legislation. So yes, maybe we'll have a talk another week, but today, I think that there's a window of an opportunity for the Constitution, for the glacier bill, and eventually for many other alternatives.
Thank you. If history is a good teacher, certainly Chile has proven its ability to be pragmatic when it comes to political solution. I want to bring the discussion back to something very specific that I think it's been brought up by Nick Copeland, who's always an avid follower of this coffee chat and often brings us great questions. And I want to bring it back to Argentina, to the San Juan province. There are at least 5 projects that could be impacted by how it is interpreted. And again, going back to Sergio's remarks at the beginning, each province has to interpret the law and apply the law. But we have El Pachón, Filo del Sol, Jose Maria, Los Azules, Valle de Chita, Altar. Most of these projects are close to the glacial inventory. So the question is, are any of these projects at risk more than others, or are they all going to be subject to the kind of process that both Sergio and Sebastián walked us through? Anybody want to comment on that?
Sure. Thanks for the question. Very interesting one indeed. As you know, San Juan, and there are some other provinces as well, is a pro-mining province. So, and has been one of the most proactive provinces in implementing the glacier law. In taking that into account, it's not the case that those projects are subject to a higher risk or anything like that. They're lucky to be in San Juan. San Juan has a large experience with the glacier law. And you mentioned quite a number of projects. You have to go into specific situation of each of them. You cannot draw a line, a single rule for all of them. First of all, the main distinction is whether they are projects existing at the time of the enactment of the law, in which case they are not subject to the prohibitions arising from the law, but rather the environmental reevaluation. And secondly, as I mentioned in my first response, the mere fact that they are near or in the area of influence of geoforms that are included on the inventory doesn't mean that the outcome of that environmental reevaluation would be negative. It takes a further study in terms of what are the activities to be conducted, how those activities could impact There are certain activities that cannot impact rock glaciers or covered glaciers, but can only impact uncovered glaciers. There's also the issue that I mentioned, that the mere fact that those geoforms are in the inventory doesn't mean that it's a non-go in terms of geoforms have been included in the inventory based on satellite features, based on a certain size, a certain dimension, and a certain longevity in terms of its existence. And that means they could have water function, but that's not the rule for all of those included in the inventory. So if I were a mining company and I were in the area of geoforms included in the inventory, I would include in my environmental study what the National Institute should have done, and it's not going to conclude, which is the further study, not just satellite imaging, but the actual water function, where it has it or not, and whether it's a relevant function or not, taking into account all the other elements contributing to the water basin. So if it's not a relevant hydrological function and contribution, then the impact is not affecting that it's subject to the protection of the law. So it doesn't mean that having projects in the area of glaciers are a non-go. It does mean that you have to make a proper evaluation of how the activities that you're going to conduct may affect the water functions, relevant contributions, if in case those exist, and those need to be verified first as well.
And that is a provincial matter, right? The authority that has competence to review, to analyze, to decide is the province, the provincial authority dealing with mining environmental issues. And even if that geoform stays in the inventory, in my view, if you are able to prove that that geoform does not have a relevant water function, and the province agrees to that, then you should not have a problem to move forward with the project, even if the inventory is not updated properly.
Yeah,
so
a
John,
word of, yeah.
So it's interesting what Sergio and Sebastián are saying, because, well, I've worked with them for more than a decade in technical legal matters. And as I said before, the key is water. Now, how do you evaluate the potential contribution of the different cryoforms? That is the key aspect to be solved. And this is why, again, we need highly robust studies, that they are framed in the legal needs. Not necessarily, and here is a bit of a word of caution, it should not be a science experiment. So here we're having an engineering project that has its time limits, budget limits, etc., where we need to understand the environment and give peace of mind to the investors, regulators, and the other stakeholders. It's not a science experiment. However, having said that, the amount of information that projects are generating is quite nice. And I've been working with several of the ones that you mentioned, John, in Argentina. And in an ideal world, there should be a better collaborative understanding in between regulators and projects in order to debunk myths that have been set a bit on stone by different parts of society, which are not necessarily true. And science in that sense will prevail to understand how these systems work in the end.
Yeah, in fact, going back to what Chile is facing in the crafting of the law, at first we were in Argentina very much concerned about what the final form of the law would be. And I mentioned this because there are different investors raise the question whether it's worth having some sort of amendment to the existing law. And we have the law that we have, right? And you're going always to have and find a tension between pro-mining and anti-mining when interpreting the law. but I wouldn't recommend pursuing an amendment or a modification of the law, because that would be opening a Pandora box now that we got to a stage where, despite the uncertainties and vagueness of the law, the different events that came along provided more and more certainty in terms of what's protected. If you ask me, and you take two groups, the pro-mining community and the anti-mining community, and you go through the different steps that have provided certainty to the national law, I would say that the anti-mining group, it's more upset with the current interpretation of the law than the pro-mining group. And so trying to solve things by amending what we have, it's kind of opening a Pandora box and not getting the best out of the evolution in terms of certainty that this law in Argentina has built up to.
Right, Sergio, I think you're absolutely right. At the end of the day, mining companies can adjust the way they approach projects. Less so once the project's developed and it's operational, but certainly they have tremendous flexibility with different technologies, different approaches today to adjust themselves. It's about clarity, it's about predictability, and that's really what they seek, like any long-term. You know, these are some of the longest term investors in the world. They can make 15 years to get their money back. So I think that that's really what it's about. I think Chile and Peru have understood that. They've developed mining laws and that have survived political gyrations left and right. And I think that other countries that aspire to reach their success, you know, need to understand that. I'm gonna end the conversation. There's no doubt we could keep going for quite some time. We've opened a Pandora's box of our own today. And there's certainly a lot to discuss. I want to thank our fabulous panelists, Sergio, Patricio, Pablo, Sebastián. Thank you so much for your time, your insights. You are now registered members of the AMI Coffee Mining Chat, which means that, like everyone else on this call, you don't have to lift a finger. We will reach out to you ahead of future coffee chats, and you can decide whether you want to join or not. They are scheduled the first Tuesday of the month. So June 1st, we will reconvene at the same time, 11 Eastern, which for the moment is also the same time in Santiago. And it's still under debate what the next mining chat will be about, but we will definitely be covering Mexico in July on the eves of their midterm elections being very important. We may very well come back to Peru, given the very likelihood of a Castillo victory, who, although he softened his stance, is certainly bringing some concern to mining investors in Peru. So we are going to continue to explore the issues of the day for mining investors. This is really about understanding mining investment risk. So we do look at issues that are environmental or legal in nature, but it always comes back to the investor's point of view. So thank you all for joining us. We really appreciate your time, and we look forward to hearing from you soon. All the best.